For legals exclusively. Polish Simplified Restructuring Proceedings 2020 Part 2 Article 20 1. The proceedings to approve the arrangement are discontinued by operation of law if the application to approve the arrangement is not filed with the court within 4 months of the day of making the announcement. 2. At the request of a debtor, the creditor or another person having a legal interest, the court issues a decision declaring that the proceedings are discontinued by operation of law. Article 21. In the case of micro-enterprises and small enterprises, the remuneration due to the arrangement supervisor may not be greater than 15% of the amount allocated to the creditors pursuant to the provisions of the arrangement, and additionally, subsection 1. If the amount allocated to the creditors pursuant to the provisions of the arrangement is greater than 100,000 Polish zloty, the portion of the remuneration greater than 100,000 Polish zloty may not exceed 3% of the amount allocated to the creditors. Subsection 2. If the amount allocated to the creditors pursuant to the provisions of the arrangement is greater than 500,000 Polish zloty, the portion of the remuneration greater than 500,000 Polish zloty may not exceed 1% of the amount allocated to the creditors. 2. If under a final and unappealable decision the arrangement is refused approval, or the proceedings are discontinued, the remuneration of the arrangement supervisor stipulated in the agreement may not exceed twice the amount of an average monthly remuneration in the enterprise sector, exclusive of profit bonus distributions for the third quarter of the previous year announced by the President of Statistics Poland. 3. Article 49 of Restructuring Law applies. Article 22. 1. Article 36 of Restructuring Law does not apply. As of the day of making the announcement, which is referred to in Article 15, Section 1, until the day on which the proceedings to approve the arrangement are discontinued or closed, the debtor may perform operations of day-to-day administration. Operations beyond the scope of day-to-day administration require the consent of the arrangement supervisor. The consent may also be granted within 30 days after having performed the operations. An operation beyond the scope of day-to-day administration, which is performed without the required consent, is invalid. 2. If the arrangement supervisor has consented, subsection 1, to conclude a credit agreement or a loan agreement, or, subsection 2, to encumber the constituents of the arrangement estate or remedial estate with a mortgage pledge, registered pledge, or a maritime mortgage in order to secure a receivable not subject to the arrangement, or, subsection 3, to transfer ownership of a thing or a right to secure a receivable which is not subject to the arrangement, or, subsection 4, to encumber the constituents of the arrangement estate with other rights, then such acts may not be deemed ineffective with regard to the bankruptcy estate or remedial estate if the information concerning such acts has been included in the application to approve the arrangement, and this application has been approved by a final and unappealable court decision. Section 3. The arrangement supervisor grants its consent to perform the acts referred to in Section 2 if it is necessary to maintain capacity to satisfy ongoing restructuring proceedings costs and liabilities arising after the restructuring proceedings have been opened or the arrangement has been concluded and performed, and if it has been guaranteed that the funds will be allocated to the debtor and used to enable implementation of the restructuring plan, and the security granted is adequate with regard to the credit or loan granted. Article 23. Within the time limit prescribed for filing an appeal pertaining to a decision to refuse approval of the arrangement, or within 7 days of the decision to discontinue the proceedings to approve the arrangement, if the discontinuation is decided after the application to approve the arrangement has been filed, the debtor may file a simplified application to open remedial proceedings, referred to in Article 328 of Restructuring Law, or a simplified bankruptcy petition, referred to in Article 334 of said Act. Article 24. If the debtor makes the announcement referred to in Article 15, Section 1 in bad faith, both the creditor and any third party are entitled to a claim to seek redress of the damage caused. Article 25. 1. Liability on account of Subsection 1. The damage caused owing to the failure to file a bankruptcy petition within the time limit prescribed in Article 21 of Bankruptcy Law. Subsection 2. The company's liabilities referred to in Article 299, paragraph 1 of the Code of Commercial Companies. Subsection 3. Tax areas referred to in Article 116, paragraph 1 of the Tax Ordinance is excluded also if the persons liable on account of the situations listed in items 1 to 3 demonstrate that within the time limits specified in Article 21, Section 1 or 2a, is excluded also if the persons liable on account of the situations listed in subsections 1 to 3 demonstrate that within the time limits specified in Article 21, Section 1 or 2a of Bankruptcy Law, they have made the announcement referred to in Article 15, Section 1, and that a final and unappealable decision on the approval of the arrangement has been made in the proceedings to approve the arrangement, or if consequently remedial proceedings have been opened or a simplified bankruptcy petition has been filed pursuant to Article 23, or that within 7 days of the decision to discontinue the proceedings to approve the arrangement pursuant to Article 20, either of the following has been filed: a bankruptcy petition or an application for the opening of remedial proceedings, which has resulted in the opening of such proceedings. Section 2. The day of filing a bankruptcy petition and the closing of restructuring proceedings, which are referred to in Article 131a of Bankruptcy Law, is also construed respectively as the day of making the announcement, which is referred to in Article 15, Section 1, and the day of the decision to discontinue the proceedings, which is referred to in Article 20. End of Part 2. Thank you. For Legal Legals exclusively.